All right, welcome back to Supreme Petition. This is our nightly focus on the presidential petition filed by NASA. Now, the 2013 petitions filed at the Supreme Court had unique aspects. It was the first time in an election where technology was listed as a main factor in the validity of the presidential election. But how did the bench rule on the different complaints leveled by the petitioners? Let's take a look back at the 2013 presidential petition.
In the 2013 presidential petition, the Supreme Court divided the issues to be heard and determined into 5. These are now known as the 5 chapters of the 2013 presidential petition. Chapter 1, Jurisdiction. The first issue that the bench deliberated on is whether the court had jurisdiction to hear the presidential petition. And the verdict was that, yes, the Supreme Court, as mandated by the Constitution of Kenya of 2010, had the jurisdiction to hear the presidential petition. Chapter 2, Vote Tallying. In the petition by Moses Kuria and Dennis Itumbi, the court had to determine what constituted a rejected vote and whether rejected or spoilt votes should be counted in determining the final tally and in computing the percentages. And the verdict was that rejected votes are not included in the final vote tallying. Chapter 3, the Voters Register. One of the most controversial aspects of the 2013 petition was the question surrounding the Voters Register. Judges had to determine what exactly the Voters Register was and whether it affected the validity of the presidential election. The bench observed that the register was verifiable and that it contained different components, which were the BVR, the Special Register, the Green Book, which was the primary reference book, and the Principal Register. Chapter 4, Electronic Support. One of the issues raised in the petition was the electronic support for the election process and its role in the validity of the presidential election. The judge's verdict was that most of the errors in the use of technology were not grievous to affect the outcome of the election. The bench noted that connectivity was an issue in most polling stations, forcing electoral officials to revert to the principal register. Their recommendation was that the DPP ought to have launched an investigation into the procurement process of the election technology. Chapter 5, Burden of Proof. The final aspect was how does one prove their allegations in an election case? The judge's verdict was that the person who claims that there was non-compliance had a duty to prove it. In the end, the overall verdict from the Supreme Court was that the election was free and fair, and the election of Uhuru Kenyatta was upheld. Those were the 5 chapters of the 2013 presidential petition.
All right, Asha Mildu taking us down memory lane with the 2013 presidential petition. And ladies and gentlemen, we'll go back to the 2017 towards the end of the show. But interesting things that came up of the 2013 petition. How much did that change our, if you could say, jurisprudence, but also just how we conduct elections? I'll start with you, Dr. Musumba. Is there anything that we did differently in 2017 as a result of some of the issues that came out of the 2013 case?
Certainly, Joe. As a result of the 2013 case, there have been several laws that have been developed, amended, to take care of certain aspects that were noted to be deficient in the 2013 elections. If we look at, for example, the register, the voter register, we have we saw that it was an audit firm actually went through the register to try and clean it up and come up with a defendable voters register. Then we also have a situation where, in terms of registering voters, the period, the announcement period and the drive to be able to register voters, there was much more clarity that was imbued during this 2017 to try and be able to show up the numbers of voters. Then, of course, when it comes to issues of tallying, there's been, of course, the systems have been tightened so that you have the forms, different forms this time round, the numbering, because if you remember, I think in 2013 it was from 16A and from 17 and the like. So now we have the regulations that were created to be able to make the presidential...
The arguments about forms haven't stopped.
No, they have.
We still argue about 34A and B in the same manner we argued about 16A in 2007, in fact.
Sure, but remember there's the court decision that said that the presidential votes will be tallied and announced at the polling station. So therefore, Form 34A, which is supposed to highlight the results of the presidential election at the polling station, Form 34B, those announced at the constituency level, and Form 34C at the National Tallying Center.
Okay, great. Kakai, I want to move along faster because we are running out of time, but to what extent is the Court of Appeal ruling in the run-up to the election about the constituency being sort of the final place where the announcement is made, and Najib Bukati's team would only sort of put things together and see who has met the threshold or not? To what extent is that going to be an issue in the petition that we are looking at here?
Yeah, if you look at the grounds that the current petition by NASA, that's one of the key things. And they're saying that actually IEBC completely failed to adhere to the guidelines that had been issued to them or clarified by the Court of Appeal. So what I'm expecting is that I expect that will take a very central stage, because that's hinging on the argument of IEBC having done so many irregularities in terms of transmitting those results, because there were specific things that they were supposed to do, and according to NASA, they did not do them. The transmission of results. And the transmission of results and tallying is one of the biggest contestation by NASA. So yes, it will form a very critical moment here, because now the court will be told exactly what the Court of Appeal decided, said, what was supposed to be done and what was not done.
Okay, Waiko, one of the things that came out of the 2013 one that we were looking at is this whole idea that even if there were problems, they were not big enough to affect the outcome. How do you come to that quantification where once whatever issues, for example, NASA brings on the table, that the judges will be looking and saying, well, this was big enough to affect or not?
In fact, Joe, I think one of the central issues in this petition will just be about that question. Starting from, was the Supreme Court right in terms of the tests that it developed? Remember, that test is in two parts. The first one is you have to show that there were significant irregularities, but secondly, you have to show that those irregularities affected the results. And I would put it as a contest between the Constitution and the Elections Act. Because when you go to the Elections Act, that's where you find that test that requires that a party bringing the petition prove both things. So for me, it becomes a central issue in terms of whether that interpretation was right, whether there should be clarification, because it could have been right, but was it properly put by the Supreme Court? Should there be some clarification? Is there a test in the Constitution that if certain aspects of the constitutions are not met, you don't look anywhere? And if I look at NASA's petition, they seem to be saying that. There is also...
That perhaps as long as certain aspects of the Constitution were flouted, it doesn't matter to what degree. Is that what you are saying?
Yes, and basically it's a very basic argument, which is that can a statute amend the Constitution or qualify the Constitution? So that's the argument we expect.
All right, we really need to bring this to a close. You won't believe that we are almost done with the hour that we had. But very, very briefly, Dr. Musumba, what can the petitioners in this case look to, for example, in terms of issues that have happened out there, President, anything that might make for a strong case based on what has happened elsewhere? I've heard you mention a few things about other cases in other parts of the world.
Thank you, Joe. As my colleague Kakai mentioned earlier on, we had recently the presidential election in Austria has been cancelled. And if you study the reasons why this election was cancelled, you'll actually discover that those reasons are very much similar to the ones that NASA alleges. So for instance, in the case of Austria, They're saying that what clerks were supposed to be doing at the respective polling stations in terms of filling out relevant forms, relevant details, in terms of transmitting results from one point to the other, that was not respected. And therefore, as a result of an investigative process, the court found that it was of such a sufficient magnitude that it negated the very reason why those rules were placed initially.
Okay, great. So if you're advising them, you'd ask them to spend the midnight oil with the Austrian case. Anyway, so Kakai, what is the biggest thing that you think this will hinge on in 30 seconds?
I think the biggest thing, if NASA, and I can tell this to their lawyers, if they really want to go through with this petition, for me, I don't think they're going far with it. But if they want to go through with this petition, one, they must really convince the Supreme Court to take back the decision they made in 2013. Mm-hmm. And how they'll do that is their magic. Because one, the Supreme Court in 2013 made very clear and profound finding on rejected votes. If that stands now, then NASA has got no ground on that. Two, it made very clear on issues of tabulation. And it said it's not the responsibility of the Supreme Court to tabulate. One of the biggest grounds for NASA is hinging on tabulation. The preliminaries will depend whether they are able to convince the Supreme Court to relook at the decision of 2013.
Your final thoughts as you answer this question, is Katiba Institute going to seek to be enjoined in this case, either as amicus or anything else?
I'm not able to answer that question directly because we do consultation before we do this. Okay. But just my closing remark in terms of what is important. I think for me and for Katiba Institute, the question is what should the public get out of this? And the critical thing is for the court to be able to clarify the law. I don't think that the 2013 judgment is very clear on so many aspects. I also think it's critical for the court to lay down the rules about the obligation of IBC, a body that is getting a lot of money, in terms of ensuring that they deliver a free, fair, credible, transparent, and accountable election.
All right, thank you very much. We can end it there. Yes, that's been the Supreme petition, our nightly focus on the presidential petition that is currently before the Supreme Court, and we'll be here every night to go through that with different legal minds in the country. Now, we're going to leave it here. My name is Joe Ageo. A big thank you to my guests here. In the next few moments, my colleague Linda Ogutu will be coming up with a news update, 1 hour of news from here and abroad. Good night. God bless.
Latin word meaning under judgment. It refers to a matter before a court or a judge that is yet to be proved or disapproved. For example, discussing the merits and demerits of the presidential petition would be sub judice.